Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Happy to see everybody here today. I want to take just a moment before we call the first case and talk about our procedure and also introduce your panel for this morning. I know we have many experienced practitioners here, and this is probably redundant, but hey, whatever. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, the proper procedure for doing that is after you've come to the podium and introduced yourself, but before you begin your argument, to request that from the court. You may reserve up to 5 minutes of rebuttal time. Appellee obviously gets no rebuttal time. We have a lighting system on the podium. We believe it to be rather straightforward. There are 3 lights on it: green, yellow, and red. So long as the light's green, you got plenty of time. If the light turns yellow, it means you're running out of time, and once the light turns red, you are out of time, and we ask that you please respect those time constraints. Also, if there is more than one attorney arguing for a side, in other words, if there are 2 parties on a side, we ask that you confer with your co-counsel and decide how to split time so we can inform the clerk so she can set the timer accordingly. One very important thing, and that's this. All the arguments in the appellate courts are now being live streamed. That sounds like we're very technologically savvy, which we're not, but anyway. The important part is this, though. Whatever you say during your argument is going to go out the minute it comes out of your mouth, and it's going to go out for everybody to hear. So please think about what you're saying. It has been embarrassing at times in the past, and we don't want it to be embarrassing in the future for anybody. Your panel this morning consists of Judge Kenny Armstrong from Memphis, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. This is Judge Smith's second day on the job. She sat yesterday and actually came back today. So we're proud of that. We didn't scare her off yesterday. Miss Angie, anything we need to take up before we call the first case?
No, Your Honor.
May call the first case, please.
Celeste, LaChapelle versus Blanchard, Tual et al.
Good morning, Your Honors.
Good morning.
Tim Edwards for the plaintiff appellant. This is a legal malpractice case which was dismissed upon summary judgment. And I've posited several arguments in my brief as to why.
Would you like to reserve any rebuttal time?
I was thinking about that, Your Honor, since I only have 15 minutes. I would like to reserve 1 minute.
1 minute. You are a brave person.
Well, I don't know, but maybe foolish is a better word.
Well, sometimes that equates to brave.
I have posited several arguments as to why the summary judgment was wrong. I'm going to focus on the one that I think is the crux of the appeal. The facts are worth running through. Mr. James Pace was a resident of Mississippi. His assets were in Mississippi, or substantially so. He was engaged to be married to the plaintiff, Ms. LaChapelle, who was a resident of Memphis. Mr. Pace became quite ill with COVID and was hospitalized in Memphis. He asked Ms. LaChapelle to engage an attorney to draft a will. The person chosen was the defendant in the case. The plaintiff knew the defendant because they both worked in the same building. The defendant had done legal work, estate work for plaintiff's father. So defendant was hired, he drafted the will, had it attested in accord with Tennessee law. Even though the first paragraph of the will, it was noted that the testator was a resident of Mississippi. The plaintiff was the executrix and the primary beneficiary. Mr. Pace passed away within several weeks of the completion of the will. The plaintiff, as executor, had the will probated, submitted for probate in the Madison County, Mississippi Chancery Court. Shortly thereafter, several Pace family members attacked the will. They intervened in the probate proceeding and ultimately filed a motion for summary judgment. The allegations as to why these Pace family members said the will was invalid were three. Number one, the mental incapacity of the decedent to execute a will. Number two, the undue influence of the plaintiff, Ms. LaChapelle. And number three, invalid witnessing under Mississippi law. So 3 counts. The summary judgment was opposed by the defendant. He filed several affidavits supporting the validity of the will. The plaintiff herself submitted an unrebutted, let me strike that. Plaintiff herself went and addressed the defendant after the summary judgment was filed, inquiring about the validity of the will. She was assured on several occasions that the will was legal and fully enforceable. Well, summary judgment ultimately was entered in Mississippi in favor of the intervening plaintiffs, the Pace family members. And the summary judgment that the chancellor in Mississippi found to justify summary judgment was the invalid attestation of the will under Mississippi law. And so upon my entry into the legal malpractice case, which was after the fact, I promptly got a tolling agreement that had the standard procedure, standard language in it saying that if the statute of limitations had expired prior to the execution of the tolling agreement, that statute of limitations defense was not waived. Filed the summary judgment motion. The trial court in Memphis entered summary judgment on the statute of limitations. Now, the basis for the trial court's ruling was that the mere filing of this, well, first of all, the trial court gave a 50-plus page oral ruling initially, which was later reduced to a more concise order, but the oral ruling was appended to the final order entered. So it's all part of the record. In that oral ruling, the trial court gave no less than 3 dates for the accrual, that is the starting gun for the statute of limitations. The first was the filing of the intervener's complaint. The second was the filing of the summary judgment. And the third was the opposition to the summary judgment. Well, those were some months apart. And the last date that the trial court mentioned would make this action timely. Now, when the court in her oral ruling was doing that, Ms. Stimick, being the good lawyer she is, artfully redirected the trial court back to away from the third date, which would make this action timely. As a trial court, as this court promptly knows, a summary judgment standard for trial court is that the court must take the strongest legitimate view of the evidence in favor of the non-moving party. That was not done. There was an unrebutted affidavit given in this action by Ms. LaChapelle saying on multiple occasions she had gone to the defendant when the probate proceeding was going on and asked the defendant about the merits of the case, and he assured her of the intervention. And he assured her that all was well. That's key.
Why is that important?
Because this court has made at least has rendered at least three decisions. Other courts of appeal have rendered decisions saying that where there is, in the underlying case, if there is a dispositive motion, such as there was in this one, and the client asks the attorney about the merits of the dispositive motion and is told that everything is all right, the courts have found that that creates an issue of fact for the jury, not for court determination. It is clear the Smith versus Hout case was a middle section case, but it was authored by Judge Golden, sitting by interchange, and it says unequivocally the question of whether a plaintiff exercised reasonable care and diligence to discover her claims is a question of fact for the jury. But let me...
Is that even though there is in this case, it's rather unique, even though you've got a separate litigation going on in a separate state on the validity, the actual question itself, and you go back to the attorney who actually doesn't represent your client, that's still a question of fact you are submitting. Is that correct?
With respect, the defendant had a continuing attorney-client relationship with the plaintiff. Under the case of Alexander versus Inman, the attorney-client relationship is formed upon first consultation and continues throughout the engagement. Alternatively...
Trial court didn't address that, did it?
No. Trial court did not. Alternatively, if the plaintiff went to Mr. Tual on these occasions and asked about the validity of the intervention action in Mississippi, that formed a new attorney-client relationship, assuming that it was not pre-existing. But there was a professional relationship. Alexander versus Inman makes it absolutely clear that there was a duty owed by the defendant to competently advise the plaintiff upon these instances. Moreover, Alexander versus Inman says that there's a fiduciary relationship that exists between attorney and client, and that was breached. I'll ask a hypothetical question.
Oh, we don't answer questions.
Well, I was not expecting Your Honor to.
Let me ask you, Mr. Edwards.
Yes, sir.
As I understand it from reading the briefs, the trial court in Mississippi decided in November of 2021 that the will was not properly executed. You don't think that that would trigger your client to understand that maybe the attorney that represented her did not act appropriately in preparing this will, and that she only had 1 year in which to file her lawsuit claiming legal malpractice?
Absolutely.
But that didn't happen, did it?
It did happen. It happened, Your Honor, because the judgment of the Mississippi court was actually entered a few days after the summary judgment. So it's November. But
November of 2021.
correct.
And the lawsuit claiming legal malpractice was filed when?
It was filed in 2023. But the
So
tolling...
how do
I'm
we
sorry.
get 1 year out of that?
Because there was a tolling agreement.
And
it was filed timely, considering the suspension of time in the tolling agreement. Within 7 months of the ruling that Your Honor is raising, there was a tolling agreement suspending the running of the statute, and it had when I terminated the tolling agreement, the lawsuit was filed within, as best recollection, 30 days. So it was timely, considering from the time that the final judgment
cite me
was
to the
entered.
language you rely on in the tolling agreement that supports your argument that you could wait until 2023 to file that action. Because as I read it, it ended on or before November 29th, 2022. Is
No,
there some
sir.
other provision I didn't see?
No, sir, that's not, I mean, respectfully, that's incorrect. The tolling agreement stopped the running of the statute, and then the provision said it can be terminated upon 30 days' notice, and then the time starts running again. So the lawsuit, considering the suspension of time, embodied in the tolling agreement, was filed within approximately 8 months from the decision of the Mississippi Chancery Court. The cases that this court has rendered that are all exactly on point about what a client knew or should have known, where there have been attorney assurances that everything was all right, are the Wilson versus Mathis case. That was authored by Judge Crawford. The Caledonia leasing case versus Armstrong Allen, where again there were assurances by an Armstrong Allen attorney that everything was all right. That's a Western Section case. Not a Western Section case, but which is on all fours, is Porter Metler versus Edwards. Here again, a motor vehicle accident was an underlying case. Motion for summary judgment filed. Attorney tells the client everything is fine. She waited more than a year to file the legal malpractice case, and the middle section, or maybe it was the Eastern District, Eastern Section, said it's okay because what your state of mind was, the second prong of the test for accrual, knowledge of the client. What your state of mind was is a factual question because the attorney has given you misinformation. So it's a question for the jury, not the court, not any court. And the last case out of this court was the Tanaka versus Amirs case. Same thing. An attorney assured the client that everything was all right in the underlying litigation when a dispositive motion was filed. And that the court found, this court found, that created an issue of fact for the jury. I see my lights up.
Yes.
And no questions. Thank you.
I do feel compelled to tell you something, though. In your argument, you seem to make a distinction between the Western Section, the Eastern Section, the Middle Section. It's one court. It makes no difference who authored the opinion. It's not a point of discussion. I just want to share that with you. One court of appeals. So you feel free to cite an Eastern decision in the West and a Western decision in the East and vice versa.
Thank you, Your Honor.
Yes, sir.
I understand.
Good morning, Your Honors. May it please the court. I'm Lauren Stemick, and together with my co-counsel Logan Klaus and Richard Glassman, we represent the Appellees, Blanchard, Tual, and Tual Graves PLLC in this case. The relevant time frame for this appeal begins with the complaint to set aside a will, which was filed in the Mississippi Chancery Court on March the 15th of 2021. The appellant, Ms. LaChapelle, received notice of that complaint. She was served, she retained counsel. Her counsel prepared and ultimately filed an answer to that complaint on her behalf on May the 10th of 2021. That is the operative date that we have argued the statute of limitations began to run, and that is the date contained in the order through which the trial court spoke. By that time, the appellant had suffered a legally cognizable injury by being forced to take some action or otherwise suffer some actual inconvenience or expense by retaining counsel and filing an answer as a result of the appellee's allegedly negligent preparation and execution of the will at issue. She had also received constructive notice of that injury by that date, in that she knew or should have known that the injury occurred as a result, again, of the allegedly negligent preparation and execution of the will. Both elements of the discovery rule having been met at that point, the statute of limitations began to run, and it expired 1 year later on or before May the 10th of 2022. That was months before the tolling agreement was entered, and it was more than a year before the lawsuit was filed. The appellant is not entitled to the additional 6 months of time that she seeks in this case that occurred between the filing of her answer in Mississippi and the Mississippi Chancery Court's entry of summary judgment against her, because the case law in Tennessee does not permit her to use the last day she suffered an injury in calculating the statute of limitations. Instead, we're required to use the first day, and that's when the clock starts. The Supreme Court in Story v. Bunstein tells us that the date of actual injury and the accrual of a legal malpractice claim is often found to have been prior to the entry of judgment in the underlying case. The statute of limitations analysis here must be performed on a case-by-case basis as a result. For example, the Story Court tells us the client may have incurred additional effort and expense in attempting to rectify the alleged negligence in the course of the underlying proceedings, and in such a case, the cause of action for legal malpractice accrues prior to entry of judgment. Turning to the notice prong, as injury appears to be waived or at least not disputed based on the appellant's briefing and argument, she relies on an affidavit that she filed in response to the first of 2 dispositive motions in this legal malpractice case for the argument that she did not know that Mr. Tual had not followed Mississippi law in the preparation of the will until the Chancery Court ruled against her on summary judgment. But the standard here is not just when she actually knew. It is when she knew or should have known in the exercise of reasonable diligence. The reasonableness component is critical here because it lends an element of objectivity to this important analysis. In Cole versus Dearborn and Ewing, the Supreme Court tells us that to be charged with constructive knowledge of an injury, the plaintiff need not actually know the specific type of legal claim she has or that the injury constituted a breach of the appropriate legal standard. Instead, she is deemed to have discovered the right of action if she is aware of facts sufficient to put a reasonable person on notice that she has suffered an injury as a result of allegedly negligent or wrongful conduct. The fact that formal action has not yet been taken against her when the statute begins to run, in this case in the form of summary judgment, is largely irrelevant following the Cole Court's reasoning because it's unnecessary for her to have suffered all of the injurious effects or consequences of the appellee's negligence in order for the statute to begin running. Now, the appellant may be correct that she suffered more injury once that order was entered, but the statute of limitations is not told by the degree of the injury. It begins to run when she was put on notice of any injury, and that occurred on or before May the 10th of 2021. The appellant has cited to several cases on this notice issue in her briefing and today in the argument, but they are all distinguished on a critical point, which is the presence of independent and very capable Mississippi counsel in that Mississippi Chancery Court case. In the Cardiac Anesthesia Services versus Jones case, this court found that a client was put on notice regarding the lawyer's allegedly negligent drafting of a contract when the allegation that that contract contained an illegal provision was first made. That court, the cardiac anesthesia court, distinguished the case before it from the Wilson versus Mathis case, which is cited by the appellant in this case, on that very basis. It's critically important. The same is true for the Porter-Mettler case that's cited by the appellant here. In those cases, the allegedly negligent lawyer was still representing the client when the assurances were made that the client used to toll the statute of limitations. That is not the case here. And in fact, no attorney-client relationship between Ms. LaChapelle and Mr. Tual has been pled in this case. In fact, the complaint simply says that the testator instructed plaintiff to engage defendant. There's no allegation of an attorney-client relationship when the will was prepared or when these assurances were made. That's simply not part of the record here. In another case cited by the appellant, Tanaka versus Mears, the Court of Appeals actually found that the client was not on notice until new counsel was retained for appeal, further emphasizing the importance of that critical factor. And we ask this court to follow the lead of the cardiac anesthesia court, which is consistent with the Supreme Court's ruling in Carvel versus Bottoms, in which the client was found to have been put on notice when he was sued over an allegedly defective deed. In that case, once that client was sued, he knew the deed was the basis for the suit, he knew who drafted it, and he knew he might lose the case. That's notice.
Let me ask you, under your argument, the statute began to run in March of 2021.
If I may, Your Honor, May of 2021.
May of 2021. So the pleading opposing the will being submitted for probate was in May of 2021?
Yes, Your Honor.
Why sign a tolling agreement in July of 2022? And what do you say was the effect of that tolling agreement?
The tolling agreement, by the very language that Mr. Edwards referenced, has no effect on this court's analysis because it contains very clear language stating that any statute of limitations defenses that existed prior to its signing are unaffected by its existence. And this statute of limitations defense existed prior to its signing because when it was signed, the statute of limitations had already expired. That was pre-suit, and so a different collection of information was available to the parties at that time than subsequently once suit had been filed. But the tolling agreement here is effectively a nullity because the statute of limitations had expired before it was entered into, and it contains specific language confirming that it does not apply where the statute of limitations has already expired, that it does not affect any such defenses.
So what was the motivation for your client to enter into the tolling agreement in July of 2022 if the statute had already expired?
Your Honor, I feel you're asking me for some privileged information there as far as my client's motivation in making a decision in the case. So I think all I can say in true candor to the court is that as often happens in litigation, additional information becomes available on an almost daily basis, especially in the early stages.
Okay.
In this case, we do ask that this court affirm the trial court's dismissal of the lawsuit against the Appellees on the basis that the statute of limitations had expired based on that May date. There may be an argument to be made, to Your Honor's reference to the March date, that it expired even earlier, but based on the proof that was before the trial court and that is in the record here, we know when that answer was filed that there can be no question. There can be no reasonable minds differing by that point. It could have occurred earlier when she was served or when she retained counsel, but those dates are not in the record. They're not before the court. What is clearly before the court is when, through independent counsel, she answered that complaint containing the very same allegations that are pled here. Addressing the fraudulent concealment argument that the appellant makes, in her affidavit, she states that Mr. Tual assured her that the will at issue was valid under Tennessee law, There's no proof in the record that he made any representations regarding Mississippi law throughout the Mississippi Chancery Court case, and that she should not be concerned about challenges to its validity. But by making this argument, the appellant essentially arguing that actual notice is required under the statute, and that when there's not actual notice, fraudulent concealment tolls the statute of limitations. But of course, that's not the law in Tennessee. In Carvel versus Bottoms, the Supreme Court explicitly rejected the notion that the client must have been advised by a professional that malpractice has occurred in order to trigger the statute of limitations. It does not matter where the notice comes from, whether it's the allegedly negligent lawyer, another lawyer, a third party, like a government agency, an opposing party, as in this case, or some other source. What matters is whether a reasonable person would have been put on notice by the information using this objective reasonableness standard. The appellant's subjective belief is not sufficient to create a factual issue here.
Do we consider the fraudulent concealment claim?
Your Honor, I think that there's a valid argument, and I believe we mentioned this in our brief, that the fraudulent concealment claim has been waived by not being included in the statement of the issues in the appellant's opening brief. We did then address it in our brief because it was addressed in the body, and we didn't want this court to be without our input on it, but I do think there is a reasonable argument to be made on that.
Okay.
As to fraudulent concealment, the trial court's finding here was based upon the timing of these alleged assurances by Mr. Tual. And the trial court found that because these assurances occurred after the filing of the complaint to set aside the will in the Mississippi case, they could not operate to toll the statute of limitations because she was already on notice. So there was no tolling to be made. Fraudulent concealment tolls the statute of limitations until the claimant discovers, or in the exercise of, again, reasonable diligence, should have discovered either the fraudulent concealment or sufficient facts to put her on notice. It is the plaintiff's burden to show that she exercised reasonable care and diligence in that investigation. The record is clear on the timeline to support the trial court's finding, but this is a de novo review, and as an additional basis, this court could find that fraudulent concealment does not apply because the assurances the appellant relies upon constituted erroneous legal advice. And the Spargas case from this court and the Cherry versus Williams case, also from this court, tell us that that does not serve as a basis to toll the statute of limitations as fraudulent concealment. Only unknown facts, not law, can serve as a basis for fraudulent concealment. There is no proof in the record here that Mr. Tual concealed unknown facts from the plaintiff. The facts pled in that Mississippi complaint to set aside the will and in this legal malpractice case are the same. They were known. There's no question there. In the Smith versus Hawk case that was referenced by the appellant in argument today, what was concealed allegedly was the identity of a tortfeasor, a critically important fact. Here, again, very different. The facts were known from the start by both sides. There's no allegation that Mr. Tual concealed the existence of an event or a document. The appellant simply alleges he gave her erroneous legal advice at a time when she had independent counsel representing her in the Mississippi case. This court has noted in Cherry versus Williams that defenses based on the statute of limitations are particularly amenable to summary judgment motions. This case fits that bill. The plaintiff appellant suffered an injury and she had constructive notice of it by May the 10th of 2021. The statute of limitations expired more than a year before suit was filed. The tolling agreement did not serve to toll that statute, nor did fraudulent concealment. So we ask that this court affirm the trial court's ruling, granting summary judgment and dismissing the case.
Thank you.
Thank you, Your Honor.
You got a minute.
All right, thank you. Your Honors, this action was filed, this intervention action was filed in Mississippi. The plaintiff went to the attorney that had drafted the will. He is an experienced attorney, and he misrepresented to her that the will was valid. He said it's valid under Tennessee law. She has no legal training. It was not a Tennessee will. Those cases, Mathis, Porter, Mettler, the cases I cited where attorneys misrepresented or led clients on to believe that the dispositive motion was no big deal, all create an issue of fact for the jury as to whether the plaintiff knew or shouldn't have known.
What about the Jones case?
Which case?
Jones versus Cardiac.
That case is something of an aberration, but we can...
Really? I wrote it.
You wrote that? All right, well, what about, you have to look at the latest Tennessee Supreme Court case.
Tennessee Supreme Court denied certiorari on it. It's published.
I'm sorry, on
On the Jones case.
okay. Well, the cases I've cited are exactly on point, Your Honor. That case did not involve attorney misleading of client. None of the cases did. Mathis didn't, Porter Mettler didn't.
Have you read the Jones case?
Yes, sir.
Okay.
I have. But also, the impact of the Story versus Bunstein case is interesting because in that case, there was the filing of a summary judgment. That didn't trigger accrual of the statute of limitations. There was entry of an interlocutory order. That didn't trigger accrual of the statute of limitations. It was only, as the Supreme Court said, when final judgment was entered did the statute of limitations get triggered. That is a 2017 case.
Thank you. You used your...
Yeah, let me ask you
Oh, go ahead.
one thing, Mr. Edwards. You talked about there being a dispositive motion, but in this case, there was a ruling in November of 2021.
That's correct, Your Honor, but I'm not arguing that the ruling did not trigger accrual. I agree that it did. I'm simply saying that the tolling agreement, which was entered into approximately 6 or 7 months thereafter, told the running of the statute. I'm not arguing with Your Honor on that point. What I'm saying is that the filing of a dispositive motion, those are not facts. It requires knowledge of facts for the first prong of the test, knowledge of facts, not allegations. And Your Honor is correct. When those allegations were reduced to judgment, yes, that is knowledge to the client. There's no question about that. But the tolling agreement caught it.
Okay.
Thank you.
Yes, sir.
Thank you, counsel. Appreciate your argument. We will review the record and endeavor to get you an opinion at the earliest possible time. You may be excused.